In other developments, the Minister of Justice is opposing the constitutional application brought by the Embrace Project on the definition of rape and consent in the Sexual Offences Act. In its arguments, the Embrace Project wants to declare the subjective test, which is currently applied in the Sexual Offences Act, unconstitutional. However, the organization argues that an objective test must be applied instead. Joining us to make sense of all of this is Leanne Germanus, Director and co-founder of the Embrace Project. Leanne, thank you very much for your time this afternoon. Let's start with a little bit of background. How did we get here?
Thank you very much for having us, and me in particular. So the way that the Embrace Project got to this constitutional challenge is we were actually approached about 2 years ago by a rape survivor who pointed out to me that in her case, the prosecution was able to prove that there was an act of sexual penetration and that she had not, in fact, given her consent to it, and that the act was unlawful. But because the state was unable to prove that the accused person subjectively intended to rape her, she did not see justice. So he was actually found not guilty. And on receiving that story and that information, I then started to do a bit more research into the definition of rape in the Sexual Offences Act. That combined with S versus Koko and the resultant outcry from acting judge Tembeka Vaitobi's ruling of also, well, basically overruling the magistrate's court and finding the accused in that case also not guilty, resulted in actually a collaboration between the Embrace Project and now our legal team. And that's actually what resulted in the constitutional challenge that the Minister of Justice now sees before him. We found that the subjective test was just actually an insurmountable barrier for the prosecution to get past, and explained a lot of the reason why we have such a high, or rather such a low rate of conviction rates when it comes to rape.
What's the subjective test? You spoke about subjectively intending to rape. What does that mean?
So rape is typically made up of 4 elements, which have to be proven beyond a reasonable doubt in order for prosecution to be able to prove that the crime did exist. The first element is unlawfulness. The second element is intent. The third element is a lack of consent. And the fourth is an act of sexual penetration. Usually an act of sexual penetration is not an issue to prove. It's often common cause that there was an act of sexual penetration. Surprisingly, consent may not also, or rather the lack of, may not always be the most difficult to prove that the complainant didn't actually consent to the act of sexual penetration. And then it follows that unlawfulness is also quite similarly simple to prove. The big problem is this element of intention. The current test used to determine whether or not intention existed, whether or not an accused person intended to commit an act of sexual penetration without the complainant's consent, is a subjective test. So the question that is asked is whether or not the accused person subjectively, in their own state of mind, thought that they were raping the person, almost completely independent of whether or not the complainant actually consented to the act of sexual penetration. And that is the problem. That subjective test that is used, where you have to go into the state of mind of the accused person, is what we're putting to the court and saying is actually unconstitutional.
Oh my. So this going into the state of mind of an accused person, is it facilitated by a psychologist, psychiatrist?
So it's usually a combination of things that have to be done to prove that. So what would typically happen in a rape case is that the prosecution, so the state, would have to sort of set the foundation for what is called a prima facie case. So, just sort of on the surface of it have shown that all of these elements existed. So there was intent, it was unlawful, there was no consent, and there was an act of sexual penetration. Then in defense, which is not very hard to do, the accused person, or rather the legal team for the accused person, has to then put into question all of these elements that have been proven by the state. And the easiest one to do that for is intent. That's usually, if it's not consent, if it's not to show that actually the complainant did consent to the act of sexual penetration, then it'll be the intent part that, no, the accused person was definitely not in any way, intending to commit an act of sexual penetration without consent. And any little bit of doubt that is created by the defense actually results in a finding of not guilty, because the standard is so high when it comes to proving crimes. It's beyond a reasonable doubt that has to be proven.
In response, the ministry says if the relief is granted to you, the organization the Embrace Project, then a revocation of the accused person's presumption of innocence would then result in that the burden of proof unjustly failing on the accused instead of the state. And they argue that it would lead to a lowering of the standard of proof from beyond a reasonable doubt to negligence, and a conviction of rape when the accused was merely negligent being too harsh a punishment. What did you understand of that?
So to be honest, I was actually quite shocked at the state's opposition of this application. It's actually a very reasonable relief that has been put forward for a test that around the world is being seen more and more as highly problematic, because it really gives more than the benefit of the doubt to the accused person, particularly when you're just looking at their subjective state of mind. I also found it quite surprising that the Minister of Justice had actually mischaracterized our application to the extent that they have, by saying that these would all be the different negative effects that would take place if our relief was actually granted. And to put that into context, the relief that we're seeking is an objective test to be applied when it comes to intent, which is one of the 4 elements that have to be proven for there to be a conviction of rape. So for us to request that instead of relying on the subjective state of mind of the individual, of an accused person, and rather looking to what a reasonable person in that situation would have understood, I cannot see how that would be a revocation of the presumption of innocence, or how it would put the burden of proof on the accused person, and also how it would result in a harsh punishment and a shifting of the burden of proof from beyond a reasonable doubt to negligence, when this is one element, intent, which is now being subjected to a different test. You still would have to prove beyond a reasonable doubt that all 4 elements existed. That means that intent would reasonably have been understood to be there. I don't see how that would diminish the burden of proof to something less than beyond a reasonable doubt, and how the burden of proof would, or rather the standard of proof, and how the burden of proof would then shift onto the accused person. It would still be the state that would have to prove all 4 of those elements for there to be a rape conviction. So I do find that contention by the state to be quite surprising and, in my opinion, a stretch.
Leanne, I ask this carefully because I generally just want to understand, because then perhaps there could be an argument, I don't know if there could be an argument made that what of men who are falsely accused of rape, right? So you find that somebody is in prison. I could not come across the stats by the time we went on air, but somebody is in prison because they were falsely accused of rape, and a couple of weeks later the charges are either dropped, or somebody then admits that, well, okay, nothing happened.
So that would in no way be affected by an objective test being applied to the element of intent. As I stated previously, if somebody is accused falsely of having committed rape, there's still a whole criminal justice system process that you have to go through in order to find a conviction of rape, the state, even if our relief is granted, would still have to prove beyond a reasonable doubt that there was sexual penetration, would still have to prove beyond a reasonable doubt that there was a lack of consent, still beyond a reasonable doubt also that there was an intent to rape, even though the test is now an objective one, saying that, if somebody is saying, no, please stop, and, doesn't necessarily push you off, it's for now the court to say, look, a reasonable person would have understood that to mean that there is no consent. So you did, in fact, intend to rape the complainant. Whereas, as the law currently stands, that would not be enough, because in the accused person's subjective state of mind, they may not have understood that to mean that there's a lack of consent. So that's the only thing that we're actually asking the court to touch on. Everything else still has to be proven beyond a reasonable doubt. It doesn't change how the legal system will prosecute people falsely accused of rape.
Yeah. Okay, so where to from here?
Well, we are now actually preparing a replying affidavit to this answering affidavit. We really did hope that the state was not going to oppose what we thought was a very reasonable application. And in not opposing it, we were hoping to come to a resolution of this application very quickly so that victims and survivors of rape could benefit from this change in law. But now we're going to have to go through the whole process, from High Court to probably Supreme Court of Appeal and all the way up to the Constitutional Court. But I think for me, the big takeaway from the answering affidavit was actually the concluding paragraph that the Minister of Justice ended with, or at least his chief director did, which was unfortunately, I guess, an attempt to reassure the public that South Africa's laws are not misogynistic. But he ends off by saying that the court is requested not to suspend anything, as the Act does not have any irregularities, and it must therefore be left as is. The applicants, being us and the rape survivor, are only driven by their egos towards men, and they are using their emotions to persuade the court to declare unconstitutional an act which is in line with the Constitution. I think we were probably most disturbed by that paragraph. It goes without saying that our faith in the government's willingness and ability to combat gender-based violence and the misogynistic and patriarchal issues that surround it is kind of lowered.
Leanne, thank you so much for your time this afternoon. Leanne Germanos is the director and co-founder of the Embrace Project.